back on the record on State versus Loyd. He's present with his attorney. State Attorney's Office is present. Y'all had enough time, or do you need more time?
Your Honor, we've had enough time. We did notice going through our notes that there are 2 jurors that have an issue we need to address with the court.
That have what?
There are 2 jurors who have a potential issue that we need to address with the court, but we're otherwise prepared.
Okay, go ahead.
So if Your Honor recalls, it feels like forever ago, but I believe it was last week, there was an issue about jurors having knowledge of Mr. Loyd's injuries and the state not having exercised the strike on jurors who were not minority but had that information. So defense counsel at our request provided us with the numbers of those jurors. We went back and looked at the transcript of the jurors and feel comfortable based upon the transcript that they don't have that information. However, given that it was an issue that was raised, we wanted to make sure that it was on the record that specifically juror number 178 and juror number 369.
What seats are they in?
I'm sorry, Judge?
What seats are they in?
It'd be helpful if I gave you that, I know.
It's 26 and 38.
Okay.
Again, based upon our review of the transcript from jury selection, maybe more specific, because as the court has been, we've been getting rough drafts every day. We reviewed them and do not believe that they have any information about the cause of the injury. But since it was raised, we wanted to make sure that if defense counsel wanted to question them about that, we don't have an objection to them doing that individually.
Ms. Miller? You got to turn your mic on. Yeah, but you don't have it on your lapel. There's no way we're going to hear it if it's on the table. Go ahead.
This is a somewhat tricky position because the defense has continuously objected to jurors being stricken based on knowledge of Mr. Loyd's injuries that occurred during the course of his arrest. However, if the court's rulings are consistently applied, juror number 178, who is in seat 26, when we spoke with him the other day, not today, the court asked about what information that juror had about this. The court's question was, how much did you hear? His answer was, basically what I remember most was the capture. Question, all right, tell me what you remember about that in as much detail. Answer, that he was captured and lost the use of an eye. Basically, that was it. And so what I would note also for the record is he is a white male. Obviously, we objected to the juror who was a younger black gentleman, played basketball in college. I believe there were 2 that we objected who had very similar information, one of whom the court asked if that juror could set aside that information, and the juror answered affirmatively, and the court still granted the state's cause. The other juror was the young man who is now a high school teacher who played basketball in college. The court did not inquire if he could set it aside, but essentially both of those jurors who happened to be black answered similarly to this juror, and this juror has not been struck for cause.
Did someone move to strike him for cause?
Juror number 178 was specifically not moved. There was no motion for cause despite the fact that we brought it to the court's attention.
Is someone now moving for cause?
No, Judge, we're just, the issue was raised, and we wanted the record to be clear that we reviewed the transcript and do not believe that they have any information. And if there's a question about that or concern, then individual inquiry would be appropriate.
If there's what?
Then if there's a question about whether or not they have information about law enforcement and the loss of the eye, this would be a good time to ask those jurors that question or those questions.
Are you moving for cause, Ms. Miller?
What I suggested the other day was that the state is only exercising cause challenges on
The
black
question I
jurors.
just asked you is, are you moving for cause?
I don't believe this is grounds for cause because this information should be.
So you're not moving for cause and you're not moving for cause.
That's correct.
You all want me to spontaneously cause a juror?
No, Your Honor.
I mean, I don't spontaneously cause people. It's not my job. Other than financial hardship, that one the court does. Yeah. So do you want him individually questioned, Mr. Williams?
No, we do not.
Ms. Miller, do you want him individually questioned on this issue?
No, the record is clear that he has information about Mr. Loyd's capture and loss of the use of an eye. He is a white man, and we have exercised cause challenges
Okay.
differently.
So the court has the record which says, I remember he was captured, I remember he lost the use of his eye, and neither party moving for cause.
Yes.
Okay. Next, we have juror in seat, and neither party asking me to ask him more questions. Yeah, this is not the court's responsibility, all right?
We're not making it the court's responsibility.
So, no, I'm making the record. This is not the court's responsibility. I will bring him in here if either side wants to ask him questions.
Understood.
All right. So moving on to juror in seat 38, number 369. Yes.
It's the exact same situation.
Ms. Miller?
I think the record is already clear, which is why I'm not asking the court to ask additional questions. His testimony was, I remember seeing the defendant's face and some comments made about him potentially being involved with some police officer. And so again, this juror, for the record, is 369 in seat 38 today. These were the answers he gave during the course of the individual questioning. He is a white man.
That he saw the defendant's face?
Correct. And so the record is clear, if I can give the context of the entirety. The court asked, can you tell me what you heard? Answer, I don't normally watch the news, but I recall just kind of walking by the TV screen, and at the beginning of every news broadcast, there's kind of a cursory, hey, this is what's going to be going on in the program type of thing. And I remember seeing the defendant's face and some comments made about him potentially being involved with some police officer. For the record, the news coverage, if it showed Mr. Loyd's face, he had a hole in his face and was bleeding pretty profusely from the night that he was arrested. And so again,
Where in that answer does it say he saw his face the night he was arrested? Did I miss you saying that?
Contextually, and I don't think there's a disagreement, I think we all interpreted him to say,
No. I do not interpret that as that being the day he was arrested. That's why I'm asking you the question. All I heard was a juror say, I was walking past the TV and I saw the defendant's face. And there were numerous, and now I'm thinking back almost 5 years, but there were numerous headshots of Mr. Loyd that were posted by the news.
I appreciate what the court is saying. I interpreted his answer to mean his face on.
I understand I just wanted the record to be clear. You're saying everyone, no. I'm not interpreting the answer that way, all right?
And that's what, given the context of the question.
All right, do you want this juror to be questioned further?
No, I am making a record that we are exercising cause challenges differently based on the race of the juror.
And are you moving for cause on this juror?
No, because I don't think that is grounds for cause, and I don't have a good faith basis to ask the court to do so.
State, are you moving for cause on this juror?
No, Your Honor.
All right, so I have two people that no one's moving for cause on with answers that could be followed up upon, but both sides declining to ask any more questions.
You got it, Judge.
Okay, thank you for bringing it to my attention.
Clear up, I do have a motion for cause on juror 38 related to a different issue.
Is it related to today's question?
Yes, ma'am.
All right, we'll get to him.
Okay.
All right? Let's just stick to one thing before the record becomes so tangled no one can follow it. All right, everybody ready to go? State.
We are.
Defense?
May we remain
Yes, you
seated?
can remain seated during this. Defense, you ready to go?
Yes, ma'am.
What says state to the juror in seat number 1?
State strike C1, Judge.
What says defense to the juror in seat number 2?
Defense would strike juror in seat number 2, 6094, because the court denied a cause challenge.
You don't need to stand during this, Ms. Miller. What says state to the juror in seat number 3?
Acceptable, Your Honor.
Defense.
Accept.
Juror in seat number 4, defense.
Accept.
State.
Acceptable, Your Honor.
Juror in seat number 5, state.
Acceptable.
Defense.
Accept.
Juror in seat number 6, defense.
Accept.
State.
State strike seat 6, Judge.
Juror in seat number 7, state.
Acceptable, Your Honor.
Defense.
Accept.
Juror in 8, defense.
Accept.
State.
Acceptable, Your Honor.
Juror in seat number 9, state.
Acceptable.
Defense.
Accept.
Juror in seat number 10, defense.
Accept.
State.
We would move the court to strike based upon her response on the law enforcement testimony question.
I apologize, I missed that. I don't object, I agree.
Okay. That juror struck for cause by agreement of the parties. State, seat 11, state.
State strike seat 11.
Ask for a race-neutral reason. Mr. Loyd is black, juror 11 is black.
State.
The general reason is her responses on capital punishments, specifically her response that she is of a Christian belief and she was unsure if she could vote for death, that God should make the decision in the end of someone's life. Though she ultimately said she could vote to impose a sentence of death, those comments give the state concern that she could actually do that. And she was on the fence, according to her language, about whether or not she had a moral or religious objection to capital punishment.
Hold on, let me get her original answers. All right, the juror did, in fact, according to my notes, make statements about religious beliefs about the death penalty, but she did say she would follow the law, but she expressed some religious qualms about it. Therefore, the court finds at this time, this is a black female, appears to be. The state has offered a race-neutral reason for the strike and grants the cause challenge.
We would object for the record.
And Your Honor, for record purposes, the state's 2 previous strikes were both white males, and the state did not strike juror in seat 8, who was a black female.
And by the way, that wasn't, I misspoke. It's not a granting of a cause challenge, grants the preemptory.
Understood, Judge. Thank
All right. Defense, juror in seat number 12,
Accept.
state.
you. Acceptable, Your Honor.
Juror in seat 13, state.
Acceptable.
Defense.
Accept.
Juror in seat 14, defense.
Accept.
State.
Acceptable, Your Honor.
Juror in seat 15, state.
Acceptable, Your Honor.
Defense.
I would exercise my second peremptory. Defense would exercise our second peremptory on juror 15 because the court denied our motion for cause.
Juror in seat 16, defense.
Accept.
State.
State strike seat 16.
Juror in seat 17, state.
Acceptable, Your Honor.
Defense.
Accept.
Juror in seat 18, defense.
Accept.
State.
Acceptable, Your Honor.
How many do I have? 11, 12. That's 12. I have 3, 4, 5, 6, 7, 8, 9, 12, 13, 14, 17, 18.
6 was struck, Your Honor.
6 was struck?
We used a peremptory on seat 6.
You're right, I just didn't cross him out. All right, so I have 11. Juror in seat 19, state.
Acceptable.
Defense.
Accept.
That's 12. 3, 4, 5, 7, 8, 9, 12, 13, 14, 17, 18, 19. 10, 11, 12. That's 12. Backstrike state.
No, Your Honor.
Backstrikes defense.
Defense would exercise our third peremptory on juror in seat number 9, juror 427.
Defense, juror in seat 20.
Accept.
State.
One moment, please, Your Honor. No, Your Honor.
Backstrikes defense.
Defense would exercise our fourth peremptory on juror in seat number 12, juror 686.
Your Honor, the state will request a race-neutral reason for the strike. All 3 prior defense strikes were of white individuals.
Ms. Miller?
And for the record, seat 12 appears to be a white female.
Similar to the state's argument on juror number 11, juror in seat 12 was much more enthusiastic in favor of the death penalty. She gave answers that suggested not only was she a proponent of it, she was more enthusiastic about it. And so in selecting a juror that's both necessary to consider guilt or innocence is also necessary if we get there to consider life or death. She is an objectionable juror because of her views on the death penalty for Mr. Loyd.
Court needs to check the original transcripts. All right, court is reading court's notes on this juror from individual voir dire. She did say she's a 6 or 7 on the death penalty as a possibility. She has an issue with racism as a mitigator. So I'm going to find that this one is race neutral and grant the strike. So we're at seat 21. What says the state?
Acceptable, Your Honor.
Defense? Backstrike state?
One moment, please, Judge.
Sure.
Thank you. If I recall, Judge, the question is to us on backstrikes?
It's to you.
Correct.
Yeah. And you said none.
Actually, we're going to backstrike seat 4.
Oh, you're backstriking 4? Okay.
Yes,
thank
Your
you.
Honor. He specifically indicated that he would have to be 100% sure to vote for death when asked questions about the death penalty during the individual voir dire.
He did say that. He said beyond a shadow of a doubt. Court wrote it down. Give me 1 second, I need to make a couple of notes here real quickly. Court does find that to be a race-neutral reason. It's not even race, it's ethnic-neutral reason. The juror said more than one time, because I wrote this one down, more than once he said he needed it to be beyond the shadow of a doubt, holding the state to a higher burden. So I do find that's a genuine reason to strike him. All right, we're at juror number 22, I believe, yeah. Defense,
We accept.
state,
22 is acceptable, Your Honor.
backstrikes defense.
Have 1 moment.
I'll get with you, yeah.
Your Honor, can I confirm who you have? I only have 11 jurors, unfortunately, by my count.
3, 5, 7, 8, 13, 14, 17, 18, 19, 20, 21, 22.
Defense accepts.
All right, that's the panel. We have one juror in seat 3, 5, 7, 8, 13, 14, 17, 18, 19, 20, 21, 22. Those are the 12. What says state to juror in seat 23 as the first alternate?
I'm sorry, Your Honor, I don't think you asked us about backstrikes.
Yeah, I did. I thought I did. But in any case, you can backstrike up until I swear. So do you have a backstrike on the 12?
We do.
Who?
Seat 7.
Seat 7?
Yes, Your Honor.
All right. State, you've used 6 strikes.
Yes, Your Honor, that's what we have. Thank you.
Okay. All right, juror in seat 23, what says the state? This would be the 12th juror. State,
Yes, Your Honor, acceptable.
defense,
We would move to strike juror 905 in seat 23 because, using a peremptory because Your Honor denied a motion for cause.
Is there a race-neutral reason on him, do you think? Because that's another white male. I could ask.
juror in seat 24, defense,
We accept.
state,
One moment, please, Your Honor.
sure.
Seat 24 is acceptable, Judge. Thank you for your patience.
Sure, no problem. Backstrikes, state,
No, Your Honor.
backstrikes, defense. That's the 12, 3, 5, 8, 13, 14, 17, 18, 19, 20, 21, 22, 24. What says defense to the juror in seat 26 as the first alternate?
How many strikes does Your Honor give for alternates?
Well, you've only used 5 of yours, so you have 5
That's true.
left. So,
I'd exercise a strike on juror 26 as the alternate.
All right, so that's your alternate strike. All right. Juror in seat 27, state,
Acceptable, Your Honor.
defense,
And so I can use my 5 peremptories on the alternates as well. And may I ask the court, how many alternates do you intend to seat?
defense,
Strike, use a peremptory on juror 27.
state, I'm sorry. So you're striking 27? You struck 26 and you're striking 27?
Yes, defense is striking jurors in seat 26 and 27, 178 and 2062.
Juror in seat 28, defense,
Accept.
state,
Acceptable.
this is the first alternate. Juror in seat 30. Who went first last time, state?
No, they did,
They
so it's our
did
turn.
state,
Acceptable.
defense,
Accept.
that's alternate number 2. Juror in seat 31, defense,
Accept.
state,
State strike seat 31.
juror in seat 32, defense, state,
Move for cause on seat 32 based upon her response regarding testimonial
No
evidence.
objection.
granted. Juror in seat 33, defense,
We're exercising a peremptory because the court denied a cause challenge.
That's 33.
juror in seat 34, state,
Acceptable.
defense,
Accept.
it's the third alternate. Juror in seat 35, defense,
Accept.
state,
Acceptable, Your Honor.
so if my records are correct, the state has struck 2 alternates, the defense has struck 3, correct?
That's what I indicate, yes, Your
All
Honor.
right, I have
Agreed.
4 alternates and 12 jurors. Juror in seat 36, state,
Acceptable, Your Honor.
defense,
Accept.
it's alternate number 5. And juror in seat 37, defense,
To strike juror 30, in seat 37, 254 for cause based on answers to giving law enforcement preferential treatment as far as credibility.
state,
No objection.
juror in seat 38, state,
Acceptable.
defense,
Move to strike juror 38 for cause. He has now referenced today Leviticus and Deuteronomy, which are both books of the Bible. On his individual questioning, he made reference to the ontological theory. And so at this point, it seems evident that there is at least some of his decision-making that is based on his faith, and rather than the court's instructions, I think there's a reasonable doubt as to his ability to set aside those faith value judgments. And so I'm moving to strike that juror for cause.
state, response.
We object, Judge. There's no record evidence of that. He may be a theologian for all we know.
Yeah, he had a lot of, he quoted philosophers, he quoted theologians, he quoted a lot of people. But he did say he could follow the law. He just seems to be one of those people that is very intellectual and has all these quotes. So I'm going to deny the cause challenge. You want to use a strike on him? An alternate?
Because the court denied a cause challenge.
Uh-huh. Okay. Juror in seat 39, defense,
Accept.
state.
Acceptable.
All right, that's the 6th alternate. That would give us 18. All right, backstrike state.
One moment to put it all together, please, Judge.
Sure.
Thank you.
I would exercise one additional
Hold on,
backstrike.
it's not your turn. Hold on. Did 27 get struck? Yeah, he did. Okay, let me mark him off.
No backstrikes from the state of Florida, Judge.
Defense?
I would exercise a backstrike on juror in seat 5, number 220, because the court denied a cause challenge.
When did you make a cause challenge on him?
And that's what I was just conferring with my notes. We did move to strike juror number, who's in seat 5 now, 220 for cause, as a result of his answers to the individual questioning.
So you're backstriking him?
Yes,
What's that state to the juror in seat 40 as an alternate?
State strikes seat 40 as an alternate.
We'd asked for a race-neutral reason. He appears to either be black or Hispanic, but not white.
State?
I don't know that there's record evidence of what nationality he is, but he said that he wasn't treated fairly by law enforcement when he was arrested for a strong arm robbery. That's our race neutral.
Was that today? Those notes from today or the last time?
His individual questioning.
Yeah, I don't remember him saying that today. All right, let me see what seat number he was.
My recollection of that juror is he indicated he was not arrested for any felonies.
Hold on. Ms. Miller, wait until I ask
Oh,
you so that the record doesn't get hopelessly confused with you just talking. Now I've lost track of what I'm looking for. Hold on. 6. There he is. I don't have any record of him saying that he was arrested. Do you have the transcript?
Not in front of us, but we can find it.
Yeah,
It was at the end of his questioning, and he indicated that he got in trouble when he was younger. And then the follow-up question was, how do you feel you were treated fairly? And he said no. Yeah, he did qualify it by saying he wouldn't hold against the state.
I'm running a search for him, but I'm not finding him. Hold on.
During the state's questioning. If I may, Your Honor.
Yes, sir.
At the end of the state's questioning, Mr. Williams asked, something in my background and my experience may not make me a good juror for that type of case. He said, gotcha. I mean, Mr. Williams said, may not be, just asking. He said, well, growing up, no, I have been arrested, not for any felonies or anything of the sort, but I mean, I don't have any bias towards anything, anybody or anything. You know, it's either you present the evidence, and if it's a fact, and you follow it. I don't judge people. Mr. Williams responded, understood. Were you treated fairly by the police and the system in that prior issue? His answer, not all the time. Question, would that affect your decision here at all? Answer, no, not at all, not at all. Everybody is different, you know, just try to present what's available, take into consideration, and then make your decision.
How is that answer different than that given by non-whites to the same question, or by whites to the same question?
I didn't hear the question, Your Honor.
The court's inquiry is this. I just didn't write it down, but we have other jurors who are not, well, who do not appear to be black, who gave that exact same answer and have not been struck. How is that answer different?
That the
What is it
state-
about him that causes concern?
The nature of the prior arrest.
The what?
The nature of the prior arrest. I know, but we know.
Is that all you have? Is that it?
It is.
In terms of your reasons for striking him?
Correct.
Ms. Miller? Ms. Miller, you wanted to say something?
I think the court's covered all of it.
Yeah, I'm going to deny that strike. I mean, we have other jurors that have given the same answers, and there was nothing about this juror that indicated to me. I didn't even write it down. That's how little it registered with the court that he had said this, that indicates to me throughout his questioning that he could not remain neutral in this case. All right, so that would make him the sixth alternate. Was that back strikes we were doing? Whose turn is it to back strike?
I don't recall, Judge.
I don't either. So back strikes defense?
We would use a peremptory on juror number 28. He's now been brought up as the 12th juror. And so we'd backstrike juror, in seat number 28, juror 68. Move for cause based on his relationship with Mr. Williams, and it was denied.
State? Anything you want to put on the record? You're striking juror in seat 28.
I heard, Your Honor. No, there's nothing on the record.
Okay.
Thank you.
So juror in seat 41, defense? And by the way, you have not used all 10 of your preemptories.
I know.
So if that, I'm just letting you know because I don't want you to suddenly tell me, I've used all 10 of my preemptories. Go ahead,
We accept 41.
defense?
We
Or, I'm
accept
sorry,
41.
state?
State strike seat 41.
Juror in seat 42, state?
One moment, please, Your Honor. No, Your Honor. Or maybe a better way to put it, I think, is acceptable. 42 is acceptable.
All right.
We're moving to strike juror 42 for cause. I don't know if the court wanted argument now or not.
Hold on, Ms. Miller. And I can't hear a word you're saying. Turn your mic on.
Is on.
Well, get it closer to your mouth. Because all I hear is like sounds coming from your table, but no actual words. All
We're
right. What says defense as to juror in seat 42?
We're moving to strike juror 42 for cause based on his answers today regarding law enforcement's credibility. He was a vociferous head nodder, indicated that law enforcement was more credible than non-law enforcement, agreed with everything juror in seat 58 said. Then we started with juror 42, then went back to juror 42.
State?
He was specifically asked the question if he would give them any more credibility. He said no. And then, as counsel pointed out, she went to seat 58, which I do believe is a cause challenge, and then went back to 42, who agreed. And then Your Honor gave the instruction about the law. So I do not believe 42 rises to the level of cause, given his prior response.
He was the juror
I
specific.
have enough, Ms. Miller, not until I ask you for another response, okay? I do not like spontaneous talking. Actually, I think there's enough doubt. I couldn't figure out whether he was going to give him more credibility or not, so I'm going to strike him. Juror in seat 43, defense,
We accept.
state.
Acceptable.
All right, back strikes, defense,
We have no back strikes.
back strike, state.
One moment, please, Your Honor.
Sure.
Thank you. No back strikes, Your Honor.
All right, seat number 3, seat number 8, seat number 13, seat number 14, 17, 18, 19, 20, 21, 22, 24, 30. That is the first 12. Alternate 1 is seat 34. Alternate 2 is seat 35. Alternate 3 is seat 36. Alternate 4 is seat 39. Alternate 40 is seat 40 is alternate 5, and seat 43 is the 6th and final alternate. Alternates will be mixed in with the regular panel. Here's what we're going to do. First thing we're going to do is Mr. Loyd. Mr. Loyd, raise your right hand. I'm going to have you affirm. Do you affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right, Mr. Loyd, if you had time to talk to your attorneys about jury selection. Have you been present throughout jury selection? Do you need any more time to talk to them about jury selection? And other than the objections your attorneys have already made, do you have any other objections to the panel that's being seated? I can't hear you, sir. All right. Thank you. All right, I'm going to bring these folks in. We're going to put them in the jury box. We're going to swear them in. We're going to release, after I've sworn the jury, I'll release the others. I'm going to send them into the jury room. We have spectators here for openings, so I'm going to bring them in. I have instructions for the spectators. I'll read preliminary jury instructions, and then you're going to do openings, no witnesses today. We have a scheduling issue to getting everybody to the hotel in a timely fashion. So once openings are done, you're done for today. I appreciate the state getting their witnesses here on time. Am I reading defendant not testifying during preliminaries or not? So you want me to leave out defendant not testifying? Okay.
Make one thing clear on the record.
Yes, ma'am.
Obviously, we have not exercised all of our peremptory challenges. However, we continue to object to the jurors being stricken for cause over defense's objection, and we believe that's embedded error that we're not waiving, and so don't accept the panel in its entirety.
You still have preemptories left. You don't want to exercise them?
No, I don't, and I understand the decision I'm making, but I do think that
Thank you. All right, let's bring them in. You know how you're calling them, right? Because I'm going to tell them. Is that everybody? We're good? All right. All right, welcome back, ladies and gentlemen. How many of you missed your clear mask and want them back? All right. When you hear, the clerk's going to call your seat number and your badge number. Pay attention because we have some duplicate badge numbers in here, which is why we're calling both. So when you hear your seat number and your badge number, follow directions of the deputies. Go.
Seat number 3, badge number 27.
Come on up, sir.
Do I take this with?
No, you can leave the paddles.
Seat number 34, badge number 294.
Do you solemnly swear or affirm that you will well and truly try the case between the state of Florida and the defendant and render a true verdict according to the laws and the evidence, so help you God?
All right, have a seat, folks. I'll be right with you all. Those of you in the audience, you were not chosen for this case. We do appreciate all of the time and attention that you gave to the matter. You are released as jurors in this case. You're discharged. You're free to go home and unpack. Have a good day, folks. All right, ladies and gentlemen, welcome to the jury. You're going to be with us for the next 2 to 3 weeks, depending on how long all of this takes. Here's what we're going to be doing for the rest of today. I'm going to give you a quick rundown. I'm going to send you into that jury room because I know all of you have phone calls you need to make. So I'm going to give you time to do that while we set up for opening statements. So what we're going to do when you come back into the courtroom is I'm going to read you the preliminary jury instructions that are read in all criminal cases, and the attorneys will have an opportunity, if they wish, to do their opening statements. We're then going to go ahead and end for today, since we've got to collect luggage, get you to the hotel, get you all settled in. They do have dinner for you this evening at the hotel. I've been told it's around 6:30, so we'll get you there in plenty of time for all of that. So preliminarily, I do have a couple of questions for you all. Do I have anyone on the jury who's a smoker? We have one? Okay. How bad is the smoking habit? How long can you go without a cigarette? 3 hours? Not too bad. Anybody else who smokes? How long can you go? You're an occasional social smoker? Ma'am in the back, are you raising your hand? How long do you need to go without can you go without a cigarette? It's oh, you have a medical issue? I'm getting to those in just a second. Any other smokers? All right, medical issues. Anybody who needs to take medication on a regular basis? Okay, I'm going to let you give the deputies the schedule you need for that medication while you're back in that room, because I need to know how often I need to call breaks. And ma'am, do you have a medical issue you need to talk to me about, or can you tell the deputies and have them tell me? No? You said you had a medical issue? Do you need to discuss it with me, or is it something you can tell the Okay, I need you to talk to the deputies about that. Anybody who forgot prescription medications, didn't pack them? Good job. And we have one hand. You forgot some of your prescription medications? All right, I need you to, again, talk to the deputies, see if that can get worked out. If there's an issue, they're going to take it up with me, all right? We'll get you your prescription meds. All right, we'll make sure you have what you need. And then this is for the future. I've got my mask. As you notice, we all wear masks in this courtroom. I have my mask off so that you all can hear me, but I wear it whenever I'm not talking to you, and I plan to continue doing that throughout the trial. Is there any juror who has any COVID issues whatsoever that, that I need to know about now? That you're uncomfortable, you're too close, anything like that? You good? All right, I'm going to send you into the jury room. You can make phone calls. There'll be deputies in there with you to take notes, figure out what all the issues are. We're going to get all that resolved today. But when you come back in, preliminary instructions and openings. Okay? Thanks, folks. All right, can everyone in the gallery hear me up there? All right, folks, you are most welcome in this courtroom. Everyone is here because they have an interest in this case. It's a public courtroom. We're happy to have you. However, there will be no outburst of any kind, and that includes folks in the gallery talking to one another. No cell phones. Turn them off. Not on vibrate. Turn them off. You may not pull your cell phone out while you're in this courtroom. The deputies have been given blanket authority by me to remove people from the courtroom who are causing a disturbance or about to cause a disturbance. I will deal with it afterwards because I'm not going to stop the trial. As I said, and I can't emphasize this enough, everyone is welcome in this courtroom and welcome to watch this trial, so long as they do not disrupt the trial. And I am certain that none of you are going to do that. We're going to take, State, how long do you need to set up?
5 or 10 minutes at the most. We just need Your Honor to give us access to the monitors whenever it's appropriate.
I thought I had turned that on. Hold on. The monitor show is on to me. Check them and see if they are. Oh, wait, no, I'm sorry. Here you go. Did that fix it? Are we good? All right. Anything else State needs?
No, Your Honor.
Defense, what do you need for your opening? Anything? Okay, so I need to give them time to talk to everyone. I'm reading 2.1 without the defendant testifying, not testifying, admonition. Hold on. I'm reading 2.1A, note-taking by jurors. I do not let jurors ask questions. That's all I'm going to, oh, I need to read 2.2 if you're going to play are you playing the video in opening?
A portion of it, yes, Your Honor.
So it's an edited recording, correct?
It is.
I think, what's your position on me reading 2.2 since they're going to get it?
No objection.
State defense. And then I have 2.4, evidence of other crimes, wrongs, or acts, since I've authorized everyone to talk about the homicide warrant for the Dixon murder. Anybody want that one read? 2.4 as part of the opening instructions.
We don't believe it's necessary because what we say is not evidence,
Okay.
but I don't object to it if the court wants to give it.
Defense, you want me to read it or not read it? All right. All right, I'm not going to read it. If the jurors start to frown or look like they can't hear you, take your mask off when you're talking to them, because
So-
they've had trouble hearing us in this courtroom.
That was going to be my next question is, would the court permit me to not wear it so long as I stay socially distanced?
As long as everyone stays socially distanced, and socially distanced means that podium. You cannot walk, well, you need to not cross the line of the end of the evidence table. That's as far as any of you can get to that jury.
Understood, Your Honor.
All right.
Thank you.
All right. 4:15, I'm going to start reading preliminaries.
Thank you, Your Honor.
Unless I get an indication that the jury's running behind on what they're doing.